Hi, my name is Sam Tooker. I'm a trial attorney here in Greenville, South Carolina at the law office, David R. Price Jr. PA. I get calls a lot from folks who have been arrested and accused of a particular crime, and they're upset because law enforcement never even got their side of the story before they were arrested. That occurs not inconsistently, and oftentimes by virtue of law enforcement's decision not to talk to a suspect, or their decision or failure to talk to other available witnesses, a case that is otherwise not a good case gets charged. Somebody gets arrested, they have to bond out, they go through the stigma and the misery of having to, stand accused and defend themselves for a crime that objectively, if all the information had been presented, it would be unlikely that a reasonable person would have concluded that they were responsible for the crime. I'm going to give you two examples of that, one from when I was a prosecutor and then one as a criminal defense attorney. The first occurred when I was prosecuting in Pickens County, and it's an example of a law enforcement agency that is understaffed and underprepared for a serious crime, failing to identify potential sources of information, getting from those sources of information things that will make more or less likely the allegation central in the case. And because they failed to identify those sources of information and get that information, somebody got arrested, charged, and prosecuted for a period of time for something that they objectively did not do, or a crime that they did not commit. So that was a case where a fellow was accused of driving drunk and killing a lady. She was a passenger in the car that he was riding in. I say she was a passenger. That was the allegation made by the police. There were three parties in the car. There was the gentleman, there was the decedent, and there was the decedent's friend. All three of them were riding in the car after having been to a couple residences and having consumed alcoholic beverages. The car ran off the shoulder of the road into some trees and rolled several times and eventually came to a stop. And the female decedent was killed because a telephone pole was sheared in half and struck her in the torso. The female occupant of the vehicle that survived said that the male was driving. The male said that the decedent was driving. So it was a case of he said, she said. Now what's fascinating about this case is it would be pretty objectively plain whether or not the decedent was driving in as much as she would be behind the steering wheel of the motor vehicle. The case was investigated by an agency that did not have many law enforcement officers, had not, to my understanding, up until that point in time, investigated a felony DUI death, and so I think was a little bit overwhelmed and a little bit underprepared to investigate the case. So we get a case that's based on two witness statements, and this guy's been accused of felony DUI. The defense attorney and I sat down and identified additional sources of information that would make more or less likely what happened in the case. One of those additional sources of information was the South Carolina Highway Patrol, who has the capacity via their MATE team to reconstruct accidents and determine how a vehicle traveled off the road, where occupants in the vehicle were sitting. And of course, nothing is certain, but it does make more or less likely certain facts and evidence. In addition to which, there were plenty of first responders who were on scene, and it turns out plenty of first responders who took photographs of the scene, none of which were compiled by the investigating law enforcement agency. We got all that information together, and what was revealed was that it was pretty plain that the decedent was driving the truck as it went off the roadway. And the reason we know that, like I mentioned, a telephone pole was sheared in half and is what caused the decedent's death. That telephone pole went straight through the windshield of the vehicle and impaled her in the driver's seat behind the steering wheel. It was so grossly evident that no one else could have been driving that vehicle that immediately upon seeing these photographs, we knew that the accused was not responsible for the crime. And so the only just thing to do, of course, under those circumstances is to dismiss the case against him. It's an eye-opening occasion as a prosecutor to find out that the case could be so wrong and the wrong decision could be so detrimental to an innocent person's life that it really does give you a reason to pause. And I am still grateful for the hard work of the first responders, of the MATE team, and of the defense attorney on the case that helped us ensure that a just result was obtained in that particular case. Second example I got is a client who was accused of criminal sexual conduct with a minor in the first degree, which, if you're aware of the potential penalties for this stuff, that is, after murder, the most serious crime that we have on the books in South Carolina. It carries 25 to life. It is a violent offense. It is a most serious offense. It is the kind of offense for which people are incarcerated for the duration of their lives. My client was a young man and a truck driver who was accused of inappropriately touching a 1.5-year-old child. Now, this is an example of the police not talking to everybody they could have talked to and obtained information that would have made more or less likely the allegation. Part of the problem in the case was it was a delayed disclosure where the child at 3 said that his uncle touched him inappropriately at 1.5. Now, what was fascinating about the case is once I sat down and talked to the client, he said it would be impossible for me to have been around that child during that period of time because I was not in the state of South Carolina. And what we were able to determine was he was in multiple states, Georgia, Oklahoma, Florida. We could document his presence in those states. When he was in South Carolina, he was not in the upstate, he was in Columbia. We could document his presence in Columbia. And for about 95 to 98% of the time in which he was accused, or the time for which he was accused of committing this crime, he was not in Greenville County. He was not in the place where the thing was to have occurred, and so it would be impossible for him to have done it. By virtue of talking to him and accumulating all of this objective evidence of his whereabouts, we were able to present that information to the prosecution, and they agreed, yeah, this is not a case that should be prosecuted. It is more than just unlikely that he is responsible for this crime. It is nearly impossible. And so the state, the solicitor's office, did the right thing, did the just thing, and dismissed the case because there was an absence of evidence that made likely my client's involvement or my client's responsibility for the alleged criminal action. So those are two examples of instances whereby law enforcement, by virtue of affirmative acts, by virtue of their failure to discuss the case with potential third-party witnesses or with the potential defendant, failed to identify sources of information that would have made much less likely the allegations central to the case. And so that's why it's real important if somebody's accused of something that they didn't do and they haven't been interviewed by law enforcement, or there are third-party witnesses that they know about that make less likely the allegation, that they talk to a lawyer. Because that lawyer is going to be able to sit down with that person or with those third-party witnesses, identify the information that makes less likely the allegation, and then present that information to the prosecution in the hopes that the prosecution agrees that the case should not be prosecuted. If you find yourself in a position like that, or you're sitting there with a circumstance where you're accused of doing something wrong, and you know you couldn't have done it because you weren't around, or because there's a witness that makes plain that you are not responsible for the alleged criminal action, call me. Phone number here is 864-271-2636. I would be happy to talk to you, and I'd be happy to help you. Thanks.